All right, team, we are just about at the hour. I'm going to start us just a minute early so I can get some housekeeping announcements out of the way. My name's Catherine. If you are with this track, you're going to see me a lot. I'm the room facilitator for this room, so I'll be with you for the next 3 days, introducing our incredible speakers, here to help and keep us on time if you need anything. So the first thing, welcome to MWise. We're so glad that you're here. If you have not already, please do download that mobile app on your phone. That's going to tell you where all the sessions are, where lunch is, all that good stuff. Lunch is at 12:15 today, so make sure you're aware of that. We also do have lunch and learn sessions at this time. They have limited space, so do try to be prompt, and they're first come, first serve. If you did not get scanned at the door, please be sure to do that for this session and every session that you attend. What scanning does is it helps us keep count, but more importantly, it gets you the survey delivered to that mobile app. And if you complete 6 surveys, you get a special swag branded gift. So definitely a hot commodity, team. Make sure you do at least 6 surveys and you can get that gift. Finally, that can be picked up at the expo floor. If you have any other questions, feel free to find me after the session. Without further ado, I am pleased to introduce Michael Eisenberg and Bob Metzger. Michael is with the Information Security Council of the American Bar Association, and Bob is a lawyer in private practice. So I'm going to turn it right over to you, gentlemen. Thank you so much for being with us today and kicking us off.
Thank you, and good morning, and welcome. Happy to be here. As our hostess has said, my name is Michael Eisenberg. I most recently spent 15 years supporting DHS and the intelligence community through the MITRE Corporation. Prior to that, most of my career as an attorney in Washington was involved in the public policy side of the IT community, working for the FCC out of law school, digital equipment for 18 years, and VeriSign, and finally MITRE for the last 15.
I'm Bob Metzger. I'm also happy to be here. In 2000, I am a lawyer in private practice. Now I'll get to the positive credentials. In 2016, I was a Federal 100 winner for work that I did that was described as sort of bringing security risks and opportunities to the attention of the federal government. I served on the Defense Science Board study of cyber supply chain risks. I was a consultant of MITRE for 5 out of the last 7 years and was a co-author of the Deliver Uncompromised report that is considered by some to have had some influence, hopefully positive, on the cyber and supply chain strategies of DoD and other agencies. In private practice, I'm primarily a litigator, but I have substantial transactional experience for complex ICT matters. Notwithstanding Google being a competitor, I was lead counsel for Microsoft in the JEDI bid protest litigation, if any of you have heard of it. So I've seen the acquisition process from a variety of perspectives, and I hope to bring those to bear in our talk today.
What we're going to be talking to you about this morning is a phenomenon that we have detected in the marketplace, and we suspect that you have probably detected it too. And the benefit that you will get out of this session may come as much from being able to put a caption around this phenomena and understand its granularity. But you've probably seen it because it's really an extension of something that we've all lived with throughout our lives. In Western economies, we all engage in various kinds of transactions. And as part of those transactions, we often try to gather information. And we call that gathering of information about the transaction we're engaging in doing due diligence. Due diligence is formally a part of many kinds of engagement, but particularly part of the process of contracting, buying and selling things, buying goods, buying services, selling those goods, and selling those services. In the IT space, due diligence is something that for many years has been a matter of gathering necessary information, what we are now understanding is necessary information, from that information that's available. And what we're observing is that increasingly the complexity of the transactions, the complexity of our products, and the risks of not having full information is something that is making that acquisition of data an imperative. And in fact, it's been recognized in many contracting environments, including those governed by the defense acquisition regs and the federal acquisition regulations, as something that needs to be written down and required in transactions. We call it a systems engineering problem because it's complex. It is part of the end-to-end process of contracting for goods and services. And we're going to hopefully leave you at the end of this session with a better understanding of what goes into it and what it's heading towards as very likely part of the routine of engagements between buyers and sellers of ICT product and service.
So my theme here is one of, let's call it mutuality or multi-directionality. And I've been a participant on capture teams, proposal teams, protest teams, dispute teams. I've responded to terminations for default. I've dealt with investigations. I've been lead counsel on a variety of False Claims Act matters brought by the federal government as well as whistleblowers. And I can say from my lengthy history that for a great deal of time, the acquisition process essentially distilled to the business side and the lawyers, along with, of course, the procurement specialists. And they were looking to enter into agreements to acquire goods and services or to sell them. But they really were not alert to or taking account of security. Well, things have changed. Now, the performance risks that confront enterprises of any kind, commercial or government, on any form of acquisition, almost any form, whether it be sell side or buy side, are highly affected by, put at risk by, supply chain risks. So the world of contracting has changed. And although you might listen to this and say, why do I care? I'm a security specialist, not a contract specialist. That's exactly why you should care. Because the businesses you work for ultimately are going to sell their goods or acquire supplies and services through a contracting process. And if that process doesn't recognize the wealth of information now available, the new tools that now can be employed, and the new opportunities and hazards from AI, I think you'll find that your business is at once both more exposed as well as missing in opportunities that could be available.
So we're going to start this off with what I hope will be a 2-minute primer on contracting law. What's a contract? It's a promise, an exchange of promises, of a promise for a promise. The classic definition is bargain for exchange of something of value from each party. Historically, contracts didn't have to be in writing. In the Middle Ages, a thing called the statute of frauds came into English common law and required that certain kinds of contracts did have to be in writing. And over the decades or the centuries, contracts are now normally in writing, and in fact they are now in most jurisdictions controlled by statute. The Uniform Commercial Code, which started being developed in the early part of the 20th century and became adopted in every jurisdiction in the United States, defines key terms in contracts. The parties, the subject matter of the contract, issues around price and delivery, warranties and other remedies. Those are now all matters of statutory requirement, and it makes it much easier for parties to understand what the elements of the contract are. But interestingly, contracts have until very recently still been governed by a classic medieval principle of caveat emptor, buyer beware. Contracts typically were a situation where there was great power, market power, sometimes referred to as contracts of adhesion because of that disparity in market power between big guy sellers and manufacturers and little guy purchasers. And the only remedy that a purchaser had throughout that pre-statutory period was to get as much information they could about whether or not the seller was trustworthy, whether or not the product that they were buying or the service they were contracting for was actually as described by the seller. And it was an uneven and equitable situation. But over time and over particularly sensitive subject matter areas, organizations like the federal government, like many state governments, started within their contracting regulations putting much more granularity, demanding much more information from the sellers in order to make sure that you had a meeting of the minds and could have a legitimate contract. And now we are moving into a space where that is changing on a wholesale basis. And what we're going to describe for you in the rest of this presentation is how those changes and migrations are being driven by the complexity of the subject matter of ICT contracts and the risks associated with many of the products that we're talking about. In particular, we're going to be focusing on contracts that are addressing critical infrastructure spaces and critical products in those spaces, especially software and microelectronics.
So I've worked on ICT contracts and formation, negotiation, drafting, and dispute over several decades. And it seems that about every decade there's some giant change in the way we buy things and what we're buying. You know, at one time we were buying packaged solutions, or we were buying computing, we were relying upon mainframes. Then we went through a period of solution development, emphasizing the now dreaded waterfall approach to software development and delivery. Well, we're at one of these paradigm shifts again. And the reason is that to have confidence or assurance in contract performance in the ICT area, and to be respectful of the public interest and the web of laws and regulations here and emerging, we have to be much more aware of the broad span of supply chain risks and make better use of the tools to understand those risks and address them. And among the tools are the human resource tools, namely the security professionals. So a key sub-theme here is that security professionals need a seat at more tables and at the higher tables for enterprises to accomplish complex ICT objectives, whether buying or selling, without taking undue supply chain risk. As a litigator, I've gone to court, or at least gone to settlement many complex ICT disputes, sometimes in the tens or hundreds of millions of dollars. Now, there was a time where, in the worst case, you'd go to court and you'd figure eventually a sensible result would occur. I think that's a little hazardous as a proposition now, because the legal system structure, practices, and standards, they're being overtaken, or maybe in some respects have been overrun by the new sources of risk and the new sources of information. So another sub-theme for me today is to urge you to help your acquisition professionals and your lawyers to do the best to get, let's call them contemporary contracts that are cognizant of supply chain risk, and take measures in those contracts to mitigate them. Don't rely upon the disputes or legal process to solve these problems. Avoid them at the outset by the right selection of vendors and by the right management of risk through the entirety of contract performance.
I want to draw your attention to the middle of this slide. I mentioned software and critical microelectronics a minute ago. They are very much the oil and steel of the information age, and they are the bleeding edge of where this tsunami of additional information both helps buyers understand more about the products they're buying and the vendors who are providing them, but that same tsunami of information creates a challenge in trying to curate it and make it useful. If at the end of the day what we're talking about is how a buyer makes a decision to trust a vendor and to trust a product of the vendor, then the information about that vendor and about its products needs to be something more than a mass of 90,000 bits of data. It needs to be useful and actionable information. And if you look at the four bullets towards the center, we're facing challenges of composition in the design, the R&D investment, and the time to market of the products we're talking about. We're facing challenges of complexity based on complexity of both the device and their supply chain. Billions of transistors, millions of lines of code, hundreds of parties up and down the supply chain of a single transaction. And with the active risks that we have, vulnerabilities that are sometimes impossible to know in their entirety and very complex, as well as the consequences.
So one of the things that's emerged in recent years is how a flaw or vulnerability in the supply chain, cyber or cyber physical, can have repercussions that extend well beyond the circle, if you will, of performance. We've seen how vulnerability in supply chain, rather in software development, can lead to a SolarWinds type event where a hostile party is able to infiltrate a widely used network management software and then potentially compromise the information systems of many companies and government entities. We've seen situations where adversaries are able to interrupt even such crucial functions as gambling at several major casinos recently. Consequences now are a reflection not just of the inherent difficulty of some jobs, but the presence of active threats and sophisticated criminal actors. This does present us with something of an explosion of information and perhaps an explosion of risks. And one of the great challenges is deciding, which of your objectives call for the investment in personnel, financial, or technical resources to make the best use of the potentially available resources. You can't solve all the problems for everything at once. Every information is constrained and every organization is constrained in resources. So here I think of the technology readiness chart where I'm looking to see, what are the risks that are most consequential in impact of a supply chain failure or breach, and what is the likelihood of the risk. And if you're up at the upper right where it's red, this is where you want to make the best use of the many available tools. I'll talk a little bit about how AI warps the game in a few minutes.
But just to put an exclamation point on Bob's point, as I guess it was Lieutenant Bromhead at Rorke's Drift who said, we've got to outgun them somewhere. But the challenge sits on both sides. As the due diligence levels the scales, the burden will be both on sellers to understand and deal with the information that it must provide to the buyer, and the buyer to understand an increasingly growing volume of data available to it about the transactions.
Let me interrupt for a second. So, often we have a kind of adversarial relationship reaching a point of inflection when the contract is made. And then after the contract is made, the teams shift, we go into performance mode. And again, we have something of a contentious relationship under the guise of cooperation and mutual support. I think that isn't really an effective model in the contemporary threat landscape. In the contract, it's important for both parties, at the time of the contract, it's important for both parties to know much more about each other and to make broader and longer term commitments of transparency and accountability. And that has implications for how contracts are performed, because what it means is that I not only want to keep track of how you're doing on milestones, I want to know when you, my seller, encounter a supply chain breach, when you, my seller, become acquired by a China-owned entity, when you, my seller, have reason to expect that you've suffered a ransomware breach. These are all things where I don't want to wait to read it in an SEC filing or read it in some, on a LinkedIn post. I want to have a duty from both sides to tell the other what's happening while it's happening, because that's the best way to mitigate risks as they mitigate vulnerabilities as they turn into events in real time. And this is something that requires, to me, the constant involvement of security professionals. Don't just throw these problems, over the back and hope that lawyers will pick them up to solve them. Lawyers can help, reduce the severity of problems, but as much as I've tried, rarely have I, as a lawyer and a litigator, solved problems so much as reduce the damage from them.
And I think that's a really critical point, which we had not yet reduced to a bullet here, but one of the elements of the new due diligence as we're observing it and conceiving it is this achievement of mutualism of both benefit and obligation. And nowhere is that more obvious than in public contracting. In commercial contracting, some of that adversarial posture residue from the caveat emptor age will inevitably still be there when you're buying your Mercedes, especially from a used Mercedes dealer. But in the public contracting space, especially when you're talking about critical infrastructures, national security items, things that there's public concern and benefit with, the obligation has to be a mutual one, because we're talking about something that is for the public good and for the benefit of both parties and for society as a whole. So driving away some of that adversarial nature and watching due diligence move towards a mutualism of obligation is something that I think we at least expect to be there.
How many of you have heard the term privity of contract? Okay, so I've done some work for MITRE, for the Office of the Secretary of Defense, and privity of contract was a great source of frustration. Privity of contract is also something that has hundreds, maybe many hundreds of years of history. Privity of contract basically says if I'm a buyer, I have rights and remedies against the seller, but I don't have really any rights or remedies against the sellers to the sellers, or the vendors to the sellers of the sellers. I can squeeze the neck of the seller to me, but I may not even know who is in the supply chain supporting that seller. Well, as we have learned too vividly, it's in the supply chain, even if it's just an air conditioning duct repair entity, if I'm thinking of Target correctly. It can be, a vendor at a very much lower tier that is the source of vulnerability that upsets everything. So, one of the problems with privity is that it typically limits not just the accountability of the lower tier to the injured buyer, but also the knowledge of the buyer of whomever is in the lower tier, what risk they present or what capabilities they possess. And so what's emerged over the past several years are methods of supply chain illumination. Those essentially are tools which involve collecting, or if you like, scraping data from many sources about who it is you're buying from, who owns them, their history of performance, their financial status, and the like.
Often just open public sources, news articles.
Public. This is all on the, the low side. And these unclassified, these are increasingly important tools to major enterprises, should be at least known to smaller enterprises, and of course, figure, prominently in the DoD and other government realm. But supply chain illumination, it's always been a form of machine learning and application of artificial intelligence. There's a massive amount of data that can be found, but making sensible use of that data requires the preparation of algorithms and the training of the data sets to produce, useful results. Being overwhelmed with data is not illumination, it's being drowned by data. And so we are in a situation where we have these wonderful new tools that carry with them some of the many complexities and huge uncertainties of, let's say it this way, AI in the marketplace.
And this is where, again, as for those of you who are worried about AI and thinking about the duality of AI, this is a great anecdotal example of where AI may help the situation by providing a means of curation of that data and organizing it to make it useful as an element of the new due diligence and leading you towards a buy, don't buy conclusion, but it may also be the source of obfuscation and abusive control of that pile of data.
If I were to, I try to read a fair amount about AI, and I'm constantly amazed at the opportunity, dazzled by the potential, horrified by the risk, and confused by the technology. And I find that each day my perception of AI's good and bads differ. And essentially every other day I'm thinking there's a different strategy for government and business to manage it. But this is a simple truth. It's upon us now, whether we like it or know it or not. From an enterprise perspective, at the very least, we want to know when our vendors are using AI. We have to demand that. We need to get transparency as to the use. We need to have some opportunity to understand, even inspect the model. We may want to know what data set is being employed. Because after all, if we are using a corrupted data set and it produces biased results, or if it can be compromised by an adversary, or if it decimates the privacy of persons whose data are affected, at a big scale, liability tends not only to flow downhill, but basically around everybody involved. And this is yet another area that emphasizes the crucial importance of security professionals. I mean, so often, for years we would see that CISOs were, somewhere relegated in the corporate decision chain. Well, obviously that is changing with this new SEC regulation. But it's more than just the CISO, and it's certainly more than the CIO. Security professionals are in the best position to know the risk, to understand the tools, and to act upon the events. And so I think, there needs to be, at the very least, a much better partnership of legal contracts and governance with security personnel.
So let's talk a little bit about how these rights and remedies for dealing with this information are coming into being. I mentioned that contracting is now controlled by a statutory structure in every state in the commercial space, and every public contract today is this, at the federal level is subject to a massive regulations, whether it's in the civilian agencies under the FAR or the defense agencies under the DFAR. So there are lots of contract terms that are specified in those regulations, everything from identity of parties and disclosure about corporate ownership or entity ownership, around pricing, around warranties and other remedies. Lots and lots of information available. But the legal marketplace is trying to catch up with the phenomena that we've been describing of the very particular granular data that goes into the complex trust decision. There's a little bit of case law beginning to emerge, not directly on point about information from technology vendors, but technology that's in the marketplace. One of the famous recent cases involves the obligation that a data collector, in this case the Wyndham Hotel chain, had to its customers whose personal information they were gathering at check-in, not just credit card numbers, but other personal information that went into their profiles as a Wyndham preferred guest. And a breach happened at the corporate level at Wyndham, and they lost control of their customer data. And eventually was an FTC investigation, and appellate law has been written that says if you're a collector of information, you have an obligation to your customer to keep control of that and to take reasonable steps to have a reasonable cybersecurity perimeter around that data to make sure that adversaries and criminals don't get access to that data. Hopefully that same theory will be extended to the kind of technical data and proprietary technical data that we'll be talking about for decades to come in the ICT space as well.
So have any of you had the privilege of looking at contract terms and conditions from a cloud service provider, whether it's SaaS or IaaS or PaaS? You probably would agree that they're artistic in the extent to which they identify risks and assign responsibility for as many as possible to the consumer or client rather than the provider. Now, I say this having done a lot of, and still doing a lot of legal work for Microsoft, which is not known for being different than that model. Well, there are changes coming. You know, the President's Executive Order 14028, the National Cybersecurity Strategy, and an increasing chorus of persons on the Hill are basically saying, wait a second, the big guys are in the best position to control these risks, but what they're doing contractually is making the victim responsible for the consequences. Those things are going to change. And so in addition to this whole sphere of data, risk, hazard, and opportunity, outside of the transaction itself, we do have to be aware of the trends in public policy and law and regulation. And yet I will say this, I'm impressed by all of the great ideas and noble public policies that are articulated in the executive order. I think there is something to be said for making a software developer more liable. I like the idea that software bills of material will increase transparency and by extension accountability. But making these things work at scale is not easy. Making them work at micro scale in your transaction isn't easy either. And so, part of the job of the security professional is to be aware of the trends and try to anticipate them. You can't comply with requirements that don't exist, but you can be closer to those requirements before they do exist.
I think it's important to remember that at the end of the day, you as business persons, as business professionals, as an element of a team, whether you're on the seller side or the buyer side, have the ability to control your own fate at the transaction by transaction level that Bob was just referring to. Until we ensconce these things in black letter statute and regulation, the individual practices of individual entities and transactions are going to go a long way towards defining what the marketplace is going to look like. If you believe what we're saying here, and I hope we haven't given you any reason to disbelieve it, hopefully you are, if you're not already using these techniques to acquire and curate the information you have around your transactions, you'll begin thinking about that and having conversations with your business partners and lawyers and other members of your team.
So Sorry. So there's, there is the marketplace, which is where we all want to be at the comfortable center of, and then there's my marketplace, which is what am I buying and what am I selling. And my marketplace really counts the most. Because, I was reading yesterday about the congressional hearings on the Blumenthal-Hawley bill for AI regulation for critical infrastructure. It has some terrific ideas. One of them is to create a new independent organization that would regulate AI and even license AI providers. How many of you think that could be accomplished in less than 5 years? Do any of you have any idea what department or agency of the federal government would host this new organization? We have and I've been a part of these, I've even contributed to some where we have these wonderful aspirations, easy to express in several nice to read paragraphs, but translating them into operational measures that people can know and understand is a lengthy and confusing process. So one of our next slides is all about self-help. You want to be alert to what's happening on the Hill, sure. Whether, it's Blumenthal-Hawley or, Senator Schumer's ideas, they're all important. But in the meantime, I'd be looking at, where does AI affect you? How could it be misused against you? How might people abuse your product? Where do you intend to employ it? How can you employ it safely? Do the smart thing at the micro level while being alert to what may eventually be required of you at the macro level.
The public policy process, the legal and regulatory framework will probably catch up with you, but what you do for yourself initially is probably going to be the most impactful on the transactions you engage in the near term.
So, there was a time when, I've been at this for 30 or some odd years, and there have been times where people take bad contracts and figure the lawyers will work it out through a claim. Or time when people take bad contracts and eventually are given a show cause notice and they figure the lawyer will litigate it. Or times when people don't want the adversary to keep a contract and they protest it. There's all kinds of ways in which lawyers and litigation and disputes have been used as business tools. Well, in these areas of supply chain risk, even though I am a lawyer, the best move is not to need lawyers for the disputes process. The much better move is to be alert at the level of each transaction to what the supply chain risk could be. Again, to understand and have accessible the tools which will help illuminate that risk and give you means to guide it. And to include terms and conditions in future contracts that keep you informed. Everybody here knows something about FedRAMP, right? Just if you don't raise your hand, just shake your head. So, one of the things that FedRAMP has, it's a pain in the neck for cloud providers, is continuous monitoring. And there are external organizations like BitSight who essentially engage in perimeter monitoring with or without your consent. Well, there's something to be said for including these rights or using these tools in the performance of ICT contracts of some significance. Because the time to learn that there's a problem with your vendor, the best time is always to learn as early as possible before the problem has matured to a fault or an event. And here again, if you think about it, there will be people in contracts, there'll be people in CIO, there'll be people in purchasing and business development in the sector. They're all going to have a stake in this, but the nature of the risk that I'm discussing, the panoply of supply chain, cyber physical system risk, these are things about which you are better trained. You will know more. You are likely to have a better appreciation of the tools and the ability to select among them. And I think the same will extend to AI as you become skillful with it. So to go back to my core theme, don't rely on lawyers to solve the problem. Do rely on security professionals to help avoid the problem.
If we can go to the next slide, please. I've already talked a little bit about the bidirectional nature of the obligation. And as we were saying a minute or two ago, you have the ability to influence the evolution of this availability of useful information, leading by example. And there's also a downside risk. One of the places that we've seen an awful lot of litigation in the last several years is in the cyber insurance space. You've probably seen cases where insurance companies are refusing to pay claims by claimant companies who have been attacked whether by ransomware or other means, because as they delve more deeply into the insurance application, 5 or 10 years ago, insurance companies eager to write cyber insurance would accept a simple checklist declaration from a potential insured describing the presence of various protective tools, and that would be enough to get the policy issued and underwritten. The insurance companies wanted the revenue. Well, as the attack surfaces have expanded and the profiles of risk have gone up, there are lots of more claims happening, and as the insurance companies have delved more deeply into the applications from their clients, they've discovered that those checkboxes were not backed up by any actual contracts with cybersecurity tool companies to protect those entities, and the insurance companies have been denying claims and failing to pay claims based on the untruths or half-truths or misstatements by applicants, and some of those cases have ended up in litigation, and a significant number of cases have been found in favor of the insurance company because of the misstatements of the vendor. So the AI phenomena and the tsunami of data phenomena that we've been talking about may lull some people into saying or doing things that might not actually be accurate. And part of the evolution of the new due diligence is going to depend on the mutuality of obligation and mutuality of trust and trustworthiness on both ends of the transaction. Leading by example in that self-help environment Bob was just talking about is going to be critical. You have the ability to change the nature of the marketplace by your own example and by encouraging your business partners to engage similarly in the provision of truthful, accurate information.
Well, Michael's quite right to mention insurability. I've actually done quite a lot of work on it. A couple of years ago, cyber insurance was just a new market, and then suddenly there were many cyber attacks, ransomware grew, and it became a loss generator for many insurers. So due diligence there has changed a lot. At first it was just a few questions. Now the questions are quite elaborate. And of course, if it turns out after an event that you make a claim and they can show that you were misleading in what you asserted you were doing or not, they can deny coverage, which doesn't help you. But increasingly, insurers are actually using some of these forensic or illumination tools. I've counseled several clients who are literally getting a list of things in different priority levels that they have to fix in order to be eligible for a policy. So the supply chain risk management function, inclusive of cyber but not limited to it, it's as you approach transactions, as you look at your own enterprise, it's very important to be seeing these areas of risk and taking active and informed steps to know and mitigate them. These are all things which will help you obtain affordable insurance with useful coverage. And for almost every enterprise, having such coverage is potentially of existential significance, because there's no one who is immune from a criminal ransomware attack. Those are the ones you know about. Well, nation-state attacks are a little different, but it's again, a chief risk officer, of course, will want to be sure that an enterprise is protected and has insurance. Part of your opportunity is to help the chief risk officer know how to assess and address the supply chain risks of your enterprise.
And I think this next one is yours, Bob. Do we wait for the government?
So, I spend a fair amount of my time watching developments on the Hill, and in theory, I'm a regulatory administrative lawyer. It takes forever. I mean, even when things are nearly an emergency, it still takes forever. Our legal system is one where problems have passed us by and morphed into something different before the regulation process begins to start. I'm impressed at how much attention is being paid on the Hill to AI. And I support the concerns about the misuse of AI with biased algorithms or to compromise privacy. And I'm glad that our lawmakers are worried about how AI could damage, even destroy critical infrastructure. And I'm satisfied that our lawmakers recognize that nation states could corrupt AI for such purposes. However, it's going to take a while for those great ideas to distill to a few, for a consensus to be reached within the Congress, for a law to be passed. And even when a law is passed, typically it can't really be implemented until you go through a rulemaking process. There's something called the Paperwork Reduction Act. Anybody heard of it? The PRA essentially is intended to free you, the people, from excess demands of paperwork. It essentially says that if the government wants to get information from more than 10 people, it has to go through its own form of rulemaking process. And so if the government, say the Department of Commerce, wanted to ask 1,000 leading AI companies to give it information upon how they structure AI, what they do to monitor and control it, well, they can't just do that without an authorizing statute and/or approval of OMB after a Paperwork Reduction Act process. So yeah, of course, I pay attention to regulations, and when they're out there, I counsel people on how to comply with them. But I also see in the cyber and supply chain area that many regulations are filled with obligations that make perfect sense in theory at a high level, but which simply cannot be applied individually to tens of thousands of companies because the circumstances of all of those companies differ. So I keep counseling, well, I counsel companies to be compliant, never to be knowingly non-compliant. But I counsel companies to be looking at, impact, let's call it impact at the critical edge. What are the key objectives of my business? Who are the key customers? What are the critical services? Who are the dependencies? Who do we rely upon and who relies upon us? Where is the greatest harm to our enterprise or to the public good if we were to suffer a supply chain compromise? I can take that circle, if you will, distinct from the larger sphere of the business, and focus my attention there and use the very powerful tools that are already available, even create new ones using AI. And I have to believe that if you protected your customer and yourself against the most acute or impactful risk, you've done the right job, and that you'll do well enough in conforming to regulations.
So we've given you quite a bit to chew on here, and probably have left some of you saying, what did they say? So we'll try to boil it down to about 5 key salient points that hopefully will leave you feeling like you've got something useful to take away from this session.
Well, systematic risk is a key issue. It is a sort of a species of what I just described. There are risks that are single to a contract, single to a vendor, single to a product. But some risks are bigger. Some risks have consequences that can ripple through your organization or from your organization to your clients, customers, even back to your suppliers. And the solar winds or the Kaseya examples are situations where single points of compromise had widespread ramification. You want to look for those. Ultimately, the word triage lends itself here, and we should have put it into the slides. Can't solve every problem. Not all of them are worth it. Not all the harms justify the expense. But you can look for areas of systemic risk or enterprise threat or of terrible consequence to the public good. And you can make decisions to prioritize your efforts there.
And to some degree, the marketplace will help you make those selections of data and make some order out of this massive new information that might be relevant to the transactions, and being aware of the fact that you're not necessarily in this alone, and there are places to turn, sources and methods that will assist the process of gathering and curating the data to make it transactionally useful. In fact, if you stick around for the next hour, Bob Martin of MITRE is going to talk about one of those processes.
Well, and data deluge, which maybe Michael used the term first, or data avalanche, pick your term. There is a huge amount of data out there. You're going to use AI or ML to help understand it. Is your AI or ML going to be any good? Is it trustworthy? Do you understand the sources of the data, how it's trained? Have you tested it against subsequent events? But you're going to have to use the data, and if you're going to use the data, then you're going to need tools to automate the use of it. Because having fantastic amounts of data is useless if you have no means to address it, and the human resource is finite. So you will be going to data analysis or AI-type tools. And then the challenge is picking wisely, not trusting it beyond perhaps the transaction or the day after. This is an area of dynamic change, and while some of the change is helpful as new tools become available with potentially transformative implications, much of the change is dangerous, or at least hazardous. And so it will be a constant vigil on the part of security professionals and at least some lawyers to be kind of aware of the trends in technology, just as we should be aware of the shape of legislation and regulation, so that we're doing the best job we can to manage our risks and protect our client interests.
If you're really efficient, we could probably take 3 20-second questions.
Yeah, we do have some friends online, so you do need to use a microphone, just in case.
Thank you. Very interesting conversation. One of my concerns is about consequence management, and it's something you didn't really talk about. In a contract, it goes pear-shaped. Apart from dollars and chasing vendors for dollars, do you see any other good recourse for consequences when there is a breach from a vendor?
I'm not sure I understood the question or heard it properly.
Sorry. If something goes wrong and there is a breach, other than demanding money or financial compensation, are there any good recommendations?
Well, no, that's a great question. You know, what are the tools you have to enforce obligations that are undertaken? In theory, you could have liquidated damages where essentially you pre-negotiate amounts of damage that you could collect upon the occurrence of certain events. You know, we see that in the service level agreements of cloud and other solution providers, where if you miss X date or fall behind, Y percentage of availability, then your revenues are reduced. It's always best to have a penalty that can be imposed more or less immediately with a limited basis of objection that has a financial consequence, but which is short of a disruptive dispute that would break the contractual relationship. I have said that we should try our best to avoid disputes, because getting complex problems into litigation is just a way to spend a lot of money to leave everybody unsatisfied. But there are times when you have to litigate, and there may be times where you have to take a vendor to court. It's a way, at the very least, of demonstrating to other vendors that you do expect that the duties that vendors assume in their contracts with you will be honored.
But that's hopefully one of the benefits of this emerging nature of due diligence, that it will provide a large amount of useful information to all parties to a transaction and avoid the contract failure that results in dispute and litigation.
Yes?
Maybe following up on that, what we often quite see is that we are very dependent on our vendors. So when they are actually impacted by ransomware, we are less interested in penalties, but actually very quickly getting to a point where we can ascertain whether it's safe for us to continue to work with them and keep connections open to the network. And we often find that actually the kind of lawyering up process hinders that resolution. Do you have any suggestions on how to actually work that into contract language?
Well, certainly, as Bob was saying earlier, in general, but specifically on that issue, you could attempt to define those situations where you want to return to going concern status as quickly as possible and seek your business partner's assistance in restoring you to that going concern posture and getting past whatever disruption was shaking your foundations.
I like an approach that avoids the risk of dispute, gives you higher confidence in the vendor you choose, where you have higher trust that's been earned not only by diligence before the transaction, but over the course of performance. But events can happen, 0 day and otherwise, that no one contemplates. In that situation, there can be much benefit to involve lawyers quickly. Often you can be in a situation where an event occurs, the character of which you don't understand, the origin of which isn't known, the impact of which hasn't been established, and yet you will find that you have obligations to report or to give notice to affected individuals. There, getting a lawyer involved early gives you the benefit of the attorney-client privilege as you take such time as is needed to understand what happened before you make decisions to fulfill your regulatory or other obligations.
But given the choice, pick a lawyer whose orientation is towards helping restore you to operation rather than taking you into litigation.
Thank you so much. On that note, we are at time and we're going to wrap up this session, but Michael and Bob might be kind enough to give you some time if you still have a question afterwards. We are going to resume here at 10 o'clock with our next session. So it's about 10 minutes from now. Take a break, do what you got to do, and we'll see you back here at 10.